Hello and welcome to Case Downtown. It's a program of Case Western Reserve University School of Law and the City Club of Cleveland. My name is Dan Moulthrop. I'm the CEO of the City Club, and I'm very delighted to be here today with Professor Michael Scharf. Michael is the acting dean of the law school. He's the John Deaver Drinko Baker Hostetler Professor of Law, a leader in the practice and study of international criminal law, and the host of the public radio program Talking Foreign Policy, all of which is wonderful, but we're actually here to talk about something else. His new book, it is called Customary International Law in Times of Fundamental Change, Recognizing Grotian Moments.
Wow.
Wow. Which sounds like a mouthful of academic jargon, but what this book is really about is how certain moments in history create the kind of conditions for new laws to emerge as a force for good on a planetary scale, which is certainly relevant today. Michael, great to see you.
Well,
Thanks for being here.
And Dan, do you want to mention who you are?
I did. I said Dan Moulthrop, CEO of the City Club, nothing else to say. Okay. So I'm going to assume that I'm not the only lawyer that's in the audience, either here in the room or watching on C-SPAN. Can we start with a couple of terms?
Sure.
We'll start with the terms in the title: Customary International Law and Grotian Moment. Which one do you want to start with?
We'll start with the Customary International Law.
Okay, Customary International.
All right. So if you were in my first year international law class, the first day in class, you would learn that the international law is made up of two types of law. Treaty law, which are these documents that countries get together and negotiate and then their parliaments ratify, and customary international law, which is the unwritten law, but is actually the more important and more pervasive part of international law. And traditionally, customary international law is thought to grow very slowly. They use the word crystallization because it takes decades, maybe centuries, for a practice to harden as a custom so that the whole world recognizes that this is something that they're bound to do. And what we've recently recognized is that sometimes these customary rules emerge very quickly, almost instantaneously. And that wrecks the whole theory of what custom is all about. And so this is the focus of the book. Now the other part, Grotian. There's this guy named Hugo Grotius, and he is thought to be the father of international law.
He's a 17th century fellow.
Yes, and he was the Mozart of law. He was a very, very gifted young man who got his PhD when he was 15, wrote his first several books before he was 20, was governor of
he's
Rotterdam.
PhD at 15, sure, but the SATs were a lot easier.
Probably so. But anyway, he wrote a book called The Laws of War and Peace at a time when Europe was run by empires. There was the Holy Roman Empire, there was the Spanish Empire, the French Empire, the Swedish Empire, and countries weren't sovereign. And his book was about how to finish and bring to a resolution the 80 Years' War, there had to be a massive peace treaty, and all the little countries of Europe should be sovereign and they should be guided by treaties between them, which would be enforceable. So he came up with this whole paradigm. And in 1648, at the Peace of Westphalia, they adopted it. And he had died during the negotiations, so he didn't get to see it through. But they called this a Grotian moment because it really launched the whole idea of sovereign states and modern international law. And so when we're looking at moments that are like paradigm shifts, where international law changes very radically and very quickly, why not call them Grotian moments? Now, there are other scholars who have different titles for this.
Now, the original Grotian moment took about a war lasting 8 decades to get to actually crystallize.
Right. So his wasn't about the swiftness, but about the radical change.
Okay.
And so other people have looked at these moments where there have been radical changes, like World War II and the advent of the UN Charter, and they say those are international constitutional moments. And they're taking a phrase from Bruce Ackerman, a famous constitutional law professor who looked at the New Deal revolution at the Supreme Court, and he said that was a constitutional moment. And so these folks are saying, well, that happens sometimes in international law, so let's call them international constitutional moments. But my problem with that
That's sort of a little bit specific to the U.S., right?
Yeah, and also, even if you analogized the UN Charter to a constitution, what we're talking about in this book is much broader. Customary international law is very broad. It's not within a constituent treaty. So we need some other title. So I argue that why not call it Grotian moments? And there's a guy, a Princeton professor named Richard Falk, who actually coined the phrase. He didn't use it quite the way I'm using it, but he was the one who gave me the idea to use this phrase.
Are people thanking you for this? For finally naming what this thing is? Or are people like, oh my God.
Some people love it, and other people say, you know, if you look at Grotius, and of course this is 4 centuries ago,
right.
He was a bit of a colonialist. And so if you're, you know, from a developing country and you're a law professor, you really don't like to have his name tagged with things. So I've run into that a little bit. Other people have this theory that Grotian moments have to be huge, you know, things like the Peace of Westphalia or the UN Charter. And what I'm talking about are mini Grotian moments, transformative moments, and maybe, you know, they shouldn't have the big G next to them. So we have these debates, but a lot of people are starting to use the phrase. When I wrote the book, there were only a couple of precedents of citations in law review articles. Just did a recent view. You can go on Lexis or Westlaw or on Google, and there are literally thousands of them now. So this word is getting out there. It's getting to be a hot word.
Why does, forgive this sort of vague sort of question, but why does this matter? Why does it matter what we call a moment of change?
Well, we have to, you know,
we got to call it something. But
framing is important.
Yeah.
You have to have a name, and part of it, there's this theory called semiotics, which political scientists and others know, which is the power of words and how their meanings change over time. And it may be that Grotius, his name and his legacy has been amplified to such an extent that it's a distortion historically. But I think everybody recognizes that Grotius, the Grotian tradition, the name Grotius is a powerful word. And so if we're coming up with a powerful new doctrine, why not give it something that has that kind of heft?
So let's then dig into, I mean, I've got some other kind of these sort of philosophical questions, but I'll hold off so while we dig into the Grotian moments that you identify.
Do you want to ask why I wrote the book to begin with?
I'm going to get there eventually. I'm going to get there eventually. But what is the prototypical Grotian moment in modern history here? You've got a few that you talk about, the trial of Nuremberg, the Truman Doctrine regarding the continental shelf and offshore oil drilling. Those are some of the first two. Where do you want to start?
There's space law,
there's
the Todich decision. I think let's start with Nuremberg, because
Okay.
everybody's pretty familiar with Nuremberg. In fact, at our law school, we had, until recently, one of the Nuremberg prosecutors on our faculty. He was the one who recruited me to teach there, Henry King. So let's start with Nuremberg.
Okay, let's start with Nuremberg and Henry King. Go ahead.
Sure.
So what makes that a Grotian moment?
All right.
In a lot of ways, it feels obvious, but unpack it for us.
So the history of war crimes prosecutions was pretty much non-existent before Nuremberg. There had been an attempt in World War I to indict the Kaiser, and then they decided not to. So there really wasn't any international war crimes prosecutions. In fact, international law prior to Nuremberg said what a country did to its own people was its own business. So there wasn't even human rights law. You just couldn't complain about what was going on within a country's own borders.
Because it was an issue of sovereignty?
It's an issue of sovereignty. So World War II and the Holocaust changes all of that. It's so radical and so fundamental that the world was ready for a completely new paradigm. And the paradigm is, if you're a leader and you commit crimes against humanity or genocide or war crimes, you can be prosecuted by the international community. And today, this isn't so novel because we see the Yugoslavia Tribunal, the Rwanda Tribunal, the Cambodia Tribunal. We see countries prosecuting their own leaders, like Saddam Hussein. They're talking about prosecuting Assad after the crisis. So today, there
are judges in Spain who want to prosecute George W. Bush.
But before World War II, nobody even thought about that. So that was the paradigm shift. And then with Nuremberg, you had the major Nuremberg trial, some Control Council Law number 10 mini trials conducted at Nuremberg by the occupying powers. Then you had the UN pass a resolution that universally endorsed the principles of Nuremberg. And these are principles we all sort of are familiar with. One, which we're talking about, is that leaders can be held responsible. Just because they're the president or the king doesn't mean they can escape liability anymore. Other ones is you can't use the obedience to orders defense. Others are that there's universal jurisdiction to prosecute international crimes. That's why in Spain they go after George Bush, for example. And then one of them is that when you prosecute people in an international tribunal, you can use a principle that is similar to the United States conspiracy Pinkerton rule or our felony murder rule. I'll stop and tell you what